The topic of today: how do you inherit your parents' house? Please teach
You're
me.
not
How do I
getting it.
inherit your house? First, you have to want to give it to me, right?
Geez, you got 3 siblings. Give me a break.
Oh, bummer. Okay, so this topic, the reason why we wanted to discuss it is we have a lot of clients that think about this all the time, and they reach out to our office. We get maybe 4 or 5 people a week that ask us to go over this same topic. So I would love, to kind of discuss the pros and cons, how people do it, what they shouldn't be doing, but what they are doing anyways, and then what our recommendations typically are. And there are different reasons for some of this, but the simplest thing, let's start with the question that you and I get all the time here at the office, Dad, which is, I want to add my kids to title. Someone told me we just need a quick claim deed. Do you do that? And that's the start of it, right?
Right.
So the first point is, yes, a lot of people do it this way, but it doesn't mean you should. And the reasons are many, they're multifaceted. The big reason that we get very hesitant to just jump right in without talking to the client more about it is taxes. There's mortgage issues, there's state issues, or any even simple things practicality wise, which is if you put your child on title, now they're one of the owners. Are they a minor, or are they not? What if they were to get a divorce? What if they got in a car accident? Is this homesteaded property? All these things. It's this
Right.
blossoming algae bloom of problems or issues. And so our job is to talk with your client and try and get them the best solution by weighing pros and cons of each. So let's talk about that first one, Dad. A quit claim deed, Q-U-I-T, quit claim deed.
You sure it's not quick?
I'm sure it's not quick. It sounds like it's quick.
Yeah, quick. I know. If you say it fast, it sounds like quick.
It sounds like it. So buyers or owners of property will ask, hey, can we do a quick claim deed? So-and-so told me at the restaurant last night, or on the golf course, or read it online. What's your thinking on a quit claim deed? Why would you use it? Who would you use it for?
I used it for my sister actually recently. It's not a quick claim deed, it's a ladybird deed. As you know, my sister has cancer, and we were looking for an easy way for the property to go to her kids when she passes. Very morbid, sorry about that. With protecting the property from creditor claims, medical bills, things like that, and avoiding probate fees. So if you got an extreme situation like I do with my youngest sister, you get them to an estate planner, you get all their documents in order, and with my sister Kelly, we use the ladybird deed, which in English is she conveys it to herself and her 4 kids. She has power in the deed to sell it and keep the money if she wants. So it's somewhat like a revocable trust. She retains complete power. In fact, she modified it recently, removing one of the 4 kids from it. So that's a quick and dirty way for people in extreme situations.
Yeah. So you kind of skipped over the quit claim deed and you went to a better solution.
Yeah.
So the quit claim deed is when you would just add someone on with you. So let's say you owned a house and you wanted to add me onto it, so that when if you were to pass away, I would
pass
get
away
the property at at that time. And it does work. We would set it up as a joint tenant. It'd be Christian Ross and Donald Ross as joint tenants with right of survivorship. And so if either one of us were to pass away, the survivor would get the full property without having to go through probate.
Right.
And
I've gotten this question 1,000 times, and then I'll throw you and your siblings under the bus. I always use my own kids as an example so that I don't feel like I'm attacking somebody else's kids. And it's for the reasons you stated, and with a few more.
Well, let's go over those individually. So let's say we add me onto title. Now you and I are 50-50 owners. Even if you think it's your house, technically it's mine now too. And what are the problems with that? I mean, could you sell without me?
I couldn't sell without you. I could make you a 1% owner, and which I
Still
guess,
couldn't sell without me, right?
no, I couldn't sell without you if you got a divorce. And then again, I use all four of my kids who all married well, and then say, look, I mean, we have not put any of our children on anything, period. The statistics are what they are. There's a 50% or better divorce rate in this country. There are people who get in car accidents, people get killed. The insurance company pays out the max of 300,000 unless you have stacked policies, and you can end up with a lien against your interest if I put you on the deed to our house. You avoid the step up in basis that we talked about. Your mother and I can each convey 12 million plus to, all of our kids. So up to 24 to 25 million dollars tax free. So we want the step up. We don't want to worry about divorces. We don't worry about any of you getting into car accidents.
Well,
Plus,
I don't want to go too far into it. The main issue that you always told me was it's my house. I get to make the decisions, right? So
there's that.
if you put me on title and I think that you've become a crazy person and you shouldn't sell and that's my house, and I could actually stop you from being able to sell it. And in its most, even if you put me at 1% or 0.1% or something like that, it could be very problematic in that scenario.
And you'll get there someday, Christian. At some point, your kids are going to be giving you advice on how you should run your life. And my standard response to your mother is, they should have met me when I was 30. You think I'm crazy now, but I was much crazier when I was younger.
Yeah, so that's kind of the simplest thing when I talk to a client is I say, look, if you put your child, your neighbor, anybody on title, you're going to need their permission to sell, mortgage, refinance, do any of those things. And that is always a possibility that it could cause you some strife, some complication. And then we kind of go into the next thing. It's okay, let's say you're not worried about that. That's fine. Well, now you've given, let's say you put me on, I'm 50% owner of
Right.
$1 million house. You've given me half of the equity in that $1 million house by adding me onto title.
Right.
That could have some real tax consequences to me, right?
Do you?
So that would be a gift tax potentially, which I think is somewhere around 40%.
Well, it's not to you. The gift tax would be imposed on me, and you file a gift tax return and it comes out of my unified credit, that 12 million plus I can devise.
But I think if you file it correctly, and so this is why these discussions that we have, we'll tell the owner, we'll say, talk to your accountant, make sure that they know what forms are going to be filed, that this is okay for your estate planning, that you're not near that $25 million exemption for a married couple on estate taxes. Talk to the accountant, make sure that they're okay with this plan, and then come back to us. Right. And so that's what we do. We say, all right, let's now assume you've talked to your accountant and you say, Christian, I still want to do it. You say, and I'm not worried about my children, giving me a hard time. I really just want to avoid probate at all costs. Well, yes, we could do a quit claim deed. You'd be multiple owners on the property. The best solution would be joint tenants with right of survivorship. And, I don't know if you can do a tenants in common, or I don't know if you can do joint tenants with percentage ownerships. I don't know if you can.
I believe you can. I could be wrong, but I think they modified that, Christian. The other thing, and this came up with your grandparents actually up north, there's liability to you if you're on the deed to my house. If I don't maintain it, or if some repair person is on the roof cleaning the gutters and they fall and break their neck, guess who's going to be a defendant? Christian Ross.
Yeah, I'll be listed. Absolutely.
So we were worried about that with your grandparents up north when they went into their reverse mortgage, that, hey, if one of us bought into the house and paid off the mortgage, if your grandfather did something crazy, I'd be a defendant, or one of your aunts and uncles would be a defendant. So that was nerve-wracking.
That can be challenging. I even had a scenario where they were like boyfriend and girlfriend that owned a property together, and then they broke up. And 10 years later, the girlfriend, the former girlfriend, stopped paying the HOA dues. And the HOA filed a lawsuit against the owners. The girlfriend was now living out of the country, so she couldn't even be served. And so they served the former boyfriend, and he got a default judgment against him. And they started garnishing his wages, which he had to explain to his now wife. It was brutal. It was so brutal.
Well, the thing people forget, and I had forgotten it until you raised it, with condos and HOAs, all the owners are jointly and severally liable for all the assessments that might come due. So you might own 1% and they decide to go after you because you have liquid assets. They go after you for the whole darn thing.
Yeah.
You know, I'm dead and gone, so they're coming after you for the
Well,
whole
and so
thing.
the other issue that you touched on briefly was a divorce or a lawsuit or something like that. And that's the thing that I personally struggle with the most when talking with my clients, because usually they'll say, hey, this is a second home. I trust them. I want them on title. And I say, well, what if, are any of them married? I say, well, no, they're not married. So, well, what if they become married? Now, the issue would be that that is an asset potentially of the marital is a marital property of your children.
Yeah.
And you wouldn't want a former daughter-in-law or son-in-law to now be arguing that they're a part owner and forcing a sale or forcing some sort of payout when this was your property. This was not your kids. You were just trying to avoid probate.
By the way,
Now,
I'm selling the house and I'm going to move to Tibet if anything happens to your mom.
all right, just make sure you let me know where you live in. So we discuss all those items. One item we haven't talked about is a mortgage. If you do have a mortgage, adding your children onto title could potentially put you in default. It doesn't,
Because
they don't usually put a buyer in default when they put a child or a spouse or someone on title, but they have the possibility for a child to put you in default. So I don't like that. You have to put them on the insurance. That could change your insurance, especially if your children have bad credit or they have prior claims, things like that. We've seen, I actually had a client whose child had an IRS lien for unpaid taxes, federal income taxes, and that attaches to everything for 10 years, and then they redo it every 10 years for another 10.
I had a client with 2 felony convictions against one of her kids, and there were restitution amounts that the court ordered. So if they were put on the deed, the court could come after that property. I have used quitclaims, not to totally dismiss them.
No, it's sometimes, and you and I talk about this all the time. We don't fight with our clients, right? So if the client asks us to do something, we'll say, okay, but we want to make sure we have that conversation about all these items, because if any one of them were to, oh yeah, that is a problem, or oh gosh, I don't want to do that. Now, if we come full circle on this, Dad, probate. Usually clients are doing this to avoid having to go through probate.
Drives me nuts.
So probate is the act of basically validating the will or non-existence of a will and appointing someone to act on behalf of the estate. So that's what probate is. There's a probate court specifically for this purpose. And in some counties, it's a pretty straightforward process, but in Florida, everything is expensive and people want to avoid it. Now, maybe it's $5,000 and a couple of months. Maybe it's $10,000 if you have a more complicated estate, or if there's some infighting, it could certainly go up from there. But you're $10,000 to probate a state in a pretty expensive area where we are, and that's not worth making $1 million mistake.
No, my first boss, Christian, I worked for a tax firm. He had a phrase: "You don't let the tax tail wag the dog." And in this case, you don't let the probate tail, $5 or $6 grand, wag the dog, which is, losing that step up, exposing the property to potential medical claims or other probate claims, when the surviving spouse passes away. You're giving up too much for too little. In most cases, if somebody is near death and they're the surviving spouse and they're going to put you on something and they just bought it yesterday and there's not much of a step up, that could save them $5 grand. That could be life or death to them.
Yeah.
But we've owned our home 26 years, so there's a big step up.
Or if, let's say they bought it with some of the children's money. So let's say they, the children are contributing to the mortgage, contributing to taxes or repairs. Well, now it's not a gift. They should be an owner. They should be protected in that sense. That's consideration. That makes a lot of sense.
There's
They're on the
homestead
mortgage.
protection, though, if your parent is ill and you're worried about medical bills and one of the kids is on the deed and it's no homestead protection as to that kid.
As to
You
that
have
kid's.
Naples Community Hospital coming after that piece of the house.
Yeah.
So, it looks simple on the surface. It really involves like a half-hour conversation.
Easily.
And I usually use you guys, honestly, just so it doesn't sound like I'm attacking their family.
Yeah, exactly.
Use
So that's our reality on quitclaim deeds. It can still be done. A lot of people do it and they get influenced by that. So they'll say, well, I talked to so-and-so and they've done it a million times. Or you go online and you'll see that it's super easy. It costs you $100 to do a quitclaim deed through LegalZoom or whomever, right? But there are all these other items that people aren't taking into consideration. And like you said, Dad, you don't let the tail of the tax or probate or any other items wag the body. That's a backwards way.
You're going to let $5,000 dictate what you do with $1 million asset?
No, yeah, exactly. So now we're going to think about, all right, if quitclaim deed isn't our solution because of one of these issues, what could the solution be? And you mentioned one of our favorites, and it's something that honestly I thought I would only learn about in law school. I didn't expect to be using it in practice, is that ladybird deed or a life estate. So to recap what that is it's a deed, it's a warranty deed,
right,
where the owner of the property is conveying it to themselves for their lifetime.
Life estate.
Yep. And then upon their passing to whomever. So
the four of you in this case. And,
yeah. So in this case, it would be Donald Ross, the grantor, to Donald Ross for his life. Right. And then upon his death to Christian Ross, in fee simple, something like that.
You keep cutting out your siblings there, Christian. They're not going to.
Well, we're keeping this simple. We're keeping this simple.
Okay.
So that's a wonderful thing for many, many reasons. Number one, I'm not an owner during your life. I have no ownership. I have no right to sell. If you do it correctly, you don't even need to ask me in order to sell. It's certain language that
There's certain language you put on it so I can
reserve.
sell it and put the money in my pocket.
Yep, exactly. You don't need a trust. You don't need to do anything like that. It's all listed right on the deed. And then upon your passing, it automatically would vest into my name by filing a death certificate and signing some sort of affidavit.
Yeah.
So really, really simple. You preserve the protection with the mortgage, so you're not in default of your mortgage. I don't need to be on the insurance. I'm not one of the owners, so I shouldn't be liable to any sort of claim or judgment or things like that. My issues would not affect this house until I became the owner. And then you keep talking about the stepped up in tax basis. You preserve that. So under the current
you preserve
tax
your
laws.
Homestead protection against medical bills, because a lot of folks, the home is their sole asset and they run up a lot of medical bills at the end of life, and that could be a lien against, if you sold it and put the money aside, or you had directions to sell it, you theoretically could expose that to creditors' claims. You want it to go to your kids. You don't want it to go to the hospital or to the government.
Yep. So that we like the ladybird deed. It's a pretty effective and inexpensive way to resolve a lot of these issues. Other issues are to set up a trust. So I used to believe, and I still kind of do, trusts are good for not everybody, but some people it's good. I actually saw an article, Dad, that said everyone in America should have a trust. And I disagree with that. I don't think that that's appropriate. However, they can be the right fit for some clients. So you'd have to hire someone to draft a trust. It can be quite expensive. It's really good for protecting big assets. It can be very tax advantageous.
Right.
It can be good for protecting your children who might have handicaps or are, they might have certain issues with, spendthrift, or, maybe they have health issues.
Addictions, mental
Addictions.
health issues, bad marriages. So there's a whole
Yes.
slew of dirty laundry things that you would use it for.
Right. The downsides would be, and actually the big upside would be that the trust doesn't pass away. The trustee might, and they'll just nominate a successor trustee. So if the trustee were to pass away, then the successor trustee would be named.
Successor trustee.
You could avoid probate in that scenario. You could avoid airing your dirty laundry in probate court and all those things. So, very wealthy or people with complex family matters. And the final arm of that is someone who maybe is not a Florida resident, but has a property down here. So they want to make sure that they're not having to subject themselves to probate in Connecticut as well as Florida. So they'll set up a trust so that maybe they still have to probate in Connecticut, but they won't have to do it here in Florida as well.
Well, you have minor children, and you don't want to give them money too young. I mean, we're signing, just not that we're re-signing our documents next Tuesday.
Yeah.
I mean,
so you've got trusts are great. You basically put the property in the name of the trustee for the benefit of the trust who has beneficiaries, and that's a great solution, but it's more expensive. It's more complicated.
Right.
The thing I don't like about it is that anytime you want to change it, you have to go to a lawyer.
Right.
It makes every question very complex, and so you're jumping on the escalator where the costs keep going up over time. So that's why I say it's really not for everybody. I think if you have one house, or if you have a more simpler family status, a ladybird deed might actually be a better solution for you. Or do nothing at all, just have husband and wife. Doing nothing at all is not a bad problem either, because probate doesn't scare us all that much. It's a one-time thing, and it's kind of done. And there might be other options. There's there Florida trusts. You can set up a land trust. You can do things like that. You could do an LLC or a corporation. You could set up a corporation, and then the corporation certainly wouldn't pass away. It would just be who owns the shares of the corporation, who's the manager of the LLC, things like that. Someone asked, what is a remainder in trust? That's basically language, if I kind of know what you're referring to. That's language you put to say anything left over is put into a trust for the benefit of beneficiaries. I'm assuming that's kind of what you're reading on, but you wouldn't normally just stop with remainder in trust. You'd have to explain, maybe it's something in a will that says, all of the remainder of my assets shall be held in trust for the benefit of my kids, something like that.
Well, the classic is when you convey a condo, a life estate and a condo to Joe Blow with a remainder interest in Joe Blow's kids.
Right.
So Joe Blow only gets it during his lifetime. Then when he passes away, he records the affidavit and the death certificate, and the remainder goes to his children. It's a partial interest in real estate.
Partial, yeah. So that's our quick and dirty summary. I mean, even talking about this with you guys was about 30 minutes or so. So you can imagine we do this with any client that were to call. You could certainly find people that will do a quitclaim deed online. And unfortunately, more often than not, they'll mess it up. So you want to make sure that you're doing it correctly, because you don't want to be penny wise but dollar foolish, or letting the tax tail wag the dog, or things of that nature.
They're never simple. People think they're simple, and there's so many layers of analysis that go into it. And
everyone's different. Everyone's different.
Yeah.
Someone asked, is the ladybird deed taxable upon transfer to children? And that's a complex answer as well, but assuming that your estate is less than the exemption amount, which I think is 12.5 million or something per person. So assuming your estate is less than 12.5 million when you pass away, your kids would inherit that property tax-free. They would get the stepped up tax basis. If they were to sell it right then and there, there'd be zero profit according to that stepped up tax. And then there's
Right.
no estate tax because you're under the 12.5 million. So hopefully
But
that
it's
would help.
not a taxable event when you record the deed in the first place because it's a contingent remainder. The kids don't have an
Yeah.
ironclad right to get that.
So that's a good point, Dad. If we were to put someone onto a quitclaim deed as a
Mhm.
50% owner and you had a mortgage, there's a tax there. There's consideration paid. You're getting you're having to pay 50% of the balance of the mortgage as a sales tax, basically, intangible and transfer tax. So
When you do the gift tax return, they actually look at the actuarial tables of, for me, for example, here I am 67, how much year and how many years I have left. And then they value your remainder interest, if it was you or anyone else, accordingly. You
yeah.
get the rest of the value.
Yeah. Couple of more questions. How long does it take? I assume you're referring to, well, I'll answer each one of these. Probate can take several months minimum, probably 3 to 6 months minimum around here. And it can be about 5 grand, 10 grand, 2,500, it's somewhere in that
Yeah.
range. Every attorney is going to be different. If you're talking about doing a ladybird deed, we tend to charge a flat rate. We do a title search, we draft the deed, we consult with the client. Currently, we're charging about $500 flat rate for that, and that's all included that's all the fees and things of that nature. But that can change. It could change in the future as well. And then someone else asked to put a property up for rent. This is a little different question. Is it recommended to change the property owner's name to an LLC? And I think it depends. So the reason why people put a property into an LLC is probably twofold. Number one, they're trying to insulate themselves from potential liability.
Right.
So the scenario, Dad, would be you have a tenant who throws a big party, someone falls down and hurts themselves and they sue you. Well,
Right.
if the property is owned by an LLC, the plan is that they would sue the LLC, not you personally. And the LLC's assets would be the only thing at risk, which would be the house, would be significant, but that's why you have insurance as well. But it wouldn't be able to go after your home where your kids and your wife sleep. That would be more protected and things like that. So that's the limit of liability.
Well, they have the piercing, the corporate bail scenario too. When people get with the LLCs, it's usually the accountant who recommends those. And I ask the client if they're going to rent the place, what's the foreseeable needs of that business? Well, it's rental. Somebody could slip and fall in the shower and, get killed, God forbid. And in those cases, you need to have insurance or have a lot of, unencumbered real estate in the LLC to avoid them piercing it. And another layer, you might just put one of the spouses as a member, so they can't go after jointly owned assets. So I would throw your mother on.
It's complex, is what you're saying. If you're gonna set a property in an LLC, you have to treat it like a business. You have to accept rent in the name of that business. You have to sign a lease in the name of that business. You have to have bank accounts in the name of that business, checks, credit cards, and you have to hire the right people. You have to hire licensed contractors, because if you are doing it, if you're doing it yourself, you could still be liable. You could be grossly negligent. It could be pierce the corporate veil, as you said. And then you also touched on the second reason people do LLCs for rentals, and that is because their accountant recommended it. The accountant's thinking you might be able to write off more expenses because you're doing it for the business. So the business will have income, which would be the rental income, and then it'll have expenses like maybe a laptop or maybe a couch or the insurance, taxes. And so you might be able to offset the expenses with the revenue and maybe even save money, get some sort of tax credit at the end of the year.
Well, some things are easier to write off in a corporation than individually too. So they'll be used for that.
Yep. So generally, yes, but there are downsides, especially if you have a mortgage and you have to treat it like it. It's not that different from the trust argument, which is now the way you own this property is a little bit more complex. Now you need to pay annual registration. You have to have an accountant. You have to change your type of insurance. The insurance could be more expensive because it's owned by an LLC. Your mortgage could be more expensive because it's owned by an LLC. But could still be the right fit. And a lot of people do use
I
it.
always ask my client, how much is your accountant going to charge you to do an annual tax return? And then there's the annual filing fee for the LLC. And could that money be better spent buying a big umbrella policy?
Yep, better insurance, better contractors, fixing anything that could cause issues, all those items.
And
Absolutely.
again, in this state, if you put it in, say, your wife's name and everything else you own is your home, your 401k and jointly owned assets, they cannot touch jointly owned assets. So sometimes people put it just in one spouse's name for an extra layer of protection.
Yeah. And that's a great example. I'm glad this person brought that up, because this is something that you might read online. You might get someone, a neighbor or a friend or a mentor, say, this is how you do it. There's a lot to this stuff. There's lots of layers. You want to make sure that you're getting the right advice.
It really is not simple.
Yeah, not simple. But it doesn't have to be perfect either. So
No.
our job is to educate the client and empower them to make a decision. And a decision based on the pros and cons of each potential issue. And that's how we run our business. It's how we want our clients to act. It's how we want, the realtors and lenders that we work with as well. Is I'm going to give you the information, I'll give you our suggestion, and then you're going to tell us how you would like to proceed. Because it's never going to be one size fits all. And what you talk about a lot, Dad, is that it's a business decision sometimes.
I leave it to the client, but I got to say, probably 3/4 of them, after I explain all the pros and cons, say, never mind.
A lot of them, yeah. We talk ourselves out of a lot of business.
Well, I just want them to know the implications of what they're doing. That's all.
Yep, I agree. All right, well, that is that's an awesome topic. And if you guys have questions about it, feel free to reach out to either of us. We'd be happy to help you or your client. And then just make sure your parents put you on title. That's the summary, right? All right.
Take care, Christian.
Good luck, guys. Bye.
Bye.